now we would like to ask the both of our speakers to give us what they think are key takeaways for this event. And we're going to go in the order in which they spoke. So Todd Seelman, if you'll take a minute to 90 seconds to sum up what you think the key takeaways are.
Sure. And if we would refer to slide 27, please. I provided 7 different best practices to avoid antitrust problems, and I think these are highly relevant. And to sum up what Shannon and I have been trying to say, which is employers that compete for employees in a certain labor pool are best to avoid communications with competing employers about compensation. Avoid it, period. If you can't avoid it, and there's reasons for communications with competing employers, then there should be compliance procedures set up, and there should be active enforcement of the compliance procedures to make sure that there's not an antitrust problem that is either brewing or is active. If red flags appear in the compliance issues dealing with human resource departments and how they determine employee compensation by use and triggering off of other employers' decisions on compensation, then seek advice of antitrust counsel, either in-house or outside, so that those things can be checked. I think the best practices of 1 through 7 are extremely important and should be checked by the participants on the call today.
Thank you very much, Todd Seelman. Dr. Shannon Seitz, some key takeaways?
So I'll leave you with 2 key takeaways. The first is that the application of antitrust laws to employers is not new, and much of the economic analysis that we've applied to antitrust violations in the product market or carry over to the labor market. And the second is just want to emphasize again the relevant market to consider, and this really goes back to Todd's points and his what not to do too, is that it's really important to think about who your competitors are for employees, not your competitors in the product space when evaluating the potential effects of these agreements.